where appropriate. This will not apply in this present case. He emphasizes that while balancing all four, a court must act to aggrandize and not diminish the rights of personal liberties of arrested individuals in line with the other interests. Finally, the same judge, Justice Professor in Joseph Diongo and 17 others, cited with acclamation, 2017 EPLR, in custody of suspect, under subsection less, it lists 4 grounds. It says, there are compelling reasons for believing that the suspects shall not appear for trial, may interfere with witnesses or the conduct of investigations, or commit an offense while on release. I am reading fast because I know the court has this record. It is necessary to keep the suspect in custody for his own protection, where the suspect is a minor for his welfare, but the suspect is serving a custodial sentence, or the suspect having been arrested in relation to the commission of an offense has breached that condition. They are not to be made in isolation, so that the court can appreciate the drafting of this section. The averments that they will continue to breach the peace are conclusive without trial. They need to be tested in trial. And while we are finalizing, we wish to express to the court that the Law Society of Kenya and other well-wishing non-governmental organizations have been able to secure fundamental progresses in constitutional interpretation in Kenya, significantly that touch on the rights of persons to assembly, to picket, and to demonstrate. One of these includes to have members of the National Police Service identify themselves while undertaking or rather engaging with peaceful protesters. 2, we also managed to get an order that the members of the National Police Service, while engaging with lawful and peaceful demonstrators, should not use weapons that will permanently leave marks on victims such as the ones before you, and also not to use noxious substances including gas or chemical-laced water. Your Honor, I want to tell you in particular that none of these orders has been complied with by the National Police Service. Why I started by saying that my colleague and my very good colleague from the DPP is doing a task almost akin to a mortician is because that application is sworn by a member of the National Police Service, a perennial continuum. Whereas today in the morning, Your Honor, we appeared before your 2 elder brothers in the High Court, Justice Mumuya and Justice Uteti. The 2 of them observed in particular that in petition E714 of 2024, the third interested party, Mr. Andrew Okiya, Omtata, Senator of Okiya County, was missing. There was an order for his physical attendance and his compliance with directions, particularly at Part 4. By close of business today, what you are being invited to do, and I would pray that it applies to all the respondents hearing, is not to continue, in fact, to violate the orders of the said court, extend the latitude that Mr. Omtata enjoys to the other respondents, and dismiss the application forthwith, release the said respondents, and allow us to personally commence malicious prosecutions against the said officer, together with the others who have been mentioned before court, Your Honor, because sooner or later we must live in a country that is governed by law and not governed by individual fear. Before I forget, Your Honor, this year, the judiciary has been the subject of the branch that the police, the National Police Service, has to offer in its ill-mannered. Your sister at Makadara, Honorable Kivuti, God rest her soul, was gunned down by members of the National Police Service, and to date, I have not seen the Inspector General issue an apology to Kenyans or even the judiciary. And these are the same people that are swearing these affidavits. I have transcended from contemners to murderers. I now wish to allow my colleague, Mr. Felix, to sum up.
Thank you very much, Your Honor. For the record, my name is Felix Keaton, and Your Honor, is to submit on two issues. First, Your Honor, is whether the motion application before you is merited, and secondly, Your Honor, is whether there are compelling reasons to further continue detain the respondents. In such a motion application, Your Honor, it should be within the square with the parameters of Section 36A. And we humbly submit, Your Honor, that Section 36A of the Civil Procedure Code places two-tier test in such a motion application. The first tier test, Your Honor, is with the investigation, and the second tier test rests with the Honorable Court. On the first tier test, Your Honor, the prosecution, the investigation, and that is, permit me, Your Honor, to refer you to Section 36A, paragraph C, whereby such an application should contain the general inquiries that have been made by the police in relation to the offense and any further inquiries proposed to be made by the police. And in such, Your Honor, the question that begs our attention is whether there are other proposed inquiries to be made before you. And in such, Your Honor, we humbly beg to refer you to paragraphs 4, 5, and 6 of the supporting affidavit of Anthony Kerini, whereby he states, Your Honor, that they intend to subject the mobile phones of the suspect to Communications Authority and to extract WhatsApp, Facebook, X messages, and photographs taken from the respondents. We humbly submit, Your Honor, that such an exercise can be undertaken when the respondents have already been released. The second reason, Your Honor, that you have been told is that they are yet to obtain CCTV footage from the nearby Java. We still submit, Your Honor, that such an exercise of extracting any slides or any CCTV footages can be done when the respondents are being released on bond and or bail. And the final reasons that you've been tendered, that they have tendered, Your Honor, they have given, is that they undertake to record witness statements. We submit, Your Honor, that any recording of witness statement, either under inquiry or charge and caution, can be done when the respondents are out. it need not be undertaken when the respondents are in custody. Your Honor, the other second tier is an obligation placed on the Honorable Court. And permit me, Your Honor, to refer you to section 36A 5, that is clause 5, whereby the court shall not make an order for the remand in custody of a suspect under section 1 unless there are compelling reasons for believing that the suspect shall not appear for trial. And secondly, Your Honor, is that it is necessary to keep the suspect in custody for his protection, and that the suspect is serving custodial sentence. Your Honor, it's our humble submission that no such reasons has been tendered before you, Your Honor, that there are compelling reasons that the respondents will not appear before you, or that it's necessary to keep them in custody for their own protection. There is no such ground. And I said, Your Honor, we humbly submit that the motion application before you is bereft of substance and the statutory blessings under section 36A of the CPC. And having submitted so, Your Honor, we inversely submit that there are compelling reasons to release the respondents on bond and on bail. And we invite you, Your Honor, to consider certain factors. First, Your Honor, is that the respondents that have a fixed abode within the Republic of Kenya. That has not been disputed. Secondly, Your Honor, we invite you to consider the primary purpose of bond and bail. That is to secure the attendance of the accused person as and when required by judicial court. And as such, Your Honor, we submit that the respondents before you shall attend judicial court as and when required. And also to further address, Your Honor, this point, we'll invite you to determine what amounts to compelling reasons that the same has been settled in the case of Republic vs. Danford Kabage, whereby Judge Mativo stated succinctly that compelling reasons that the prosecution should place material information before the Robo Court to demonstrate the compelling reasons. And as such, Your Honor, we submit that within the ambit of the law, the motion application before you is bereft of substance and merit and legality. And we humbly invite you, Your Honor, to consider also Article 49(1)(h) of the Constitution, that an arrested person has a right to be released on bond and or bail on reasonable conditions, unless there are compelling reasons. And having submitted that there are no compelling reasons, we humbly invite you, Your Honor, to proceed and to strike for the rule of law and to unleash your sword of Damosin and to release the respondents on bond and or bail. And we humbly propose, Your Honor, that free bond should be sufficient to secure their attendance to the court. Reason being, Your Honor, the freedom songs rings loudly, Your Honor, that hatuna bunduki, hatuna rungu. They are just harmless people fighting for the rights of the Republic of Kenya. And as such, Your Honor, we humbly invite you to release them on bond and on bail in order to nourish and flourish the tree of freedom and liberty. We so submit, Your Honor.
That will add the submission for the respondents.
Your Honor, I do apologize for coming late. I did not know that the proceedings were on. Until my secretary pointed out to me that accidentally he has come to know that the case is on. There are only two things I wish to say to Your Honor. We administer justice in fairness, equity, and when we come to court, we must come to court with harms. What is happening to the senator is despicable, deplorable, reflects a banana republic party at its worst. Your Honor, Mr. Ndego, my friend Mr. Ndego and myself spent about 4 hours at the office of the OCP in Nairobi. One, we just wanted to see Senator Omtata at his council who was denied that opportunity, although he was at the police. Secondly, Your Honor, the senator is a sick man, and his brother had the medicine. I saw the medicine with my own eyes. We wanted to make sure that he continued to be alive and in good health. We pleaded with the police, senior police officer was in many hours. I had even the opportunity to address our learned media on what is going on. He was denied medicine and procedure. Your Honor, the senior police officer must have been acting on instructions from legal advisors. He must have been acting on advice from the senior police officer. Your Honor, for them now to come with this document, which I've just seen here, and ask for certain orders, I'm asking you very respectfully, rise to the occasion and say to them, no, that will not be the position in Kenya, where you are deny a client an advocate his right to your counsel under the Constitution. Where you deny a client or a suspect medicine as required by the Constitution. There are very clear provisions in the Constitution. One of them, if I may borrow the word, says that a person shall not be denied medicine or treatment at all. He was. Your Honor, we have had enough of this, of what is going on in the country. No wonder that the Kenyans are now filing a petition at the Hague of the position that the country finds itself. Rise to the occasion and show the people outside that there is still rule of law in the country. That we are not yet a banana republic. That's for your Honor. Reject what the DPP has said. It's a disaster. That's not what we fought for. That's not what the founding fathers fought for. It's disgraceful and to embarrass people like ourselves have had to run so many within a short time to be here. I'm doing so at my age of 88 to ensure that we have a rule of law in the country. Thank you.
Well, maybe Senior Counsel can sum up for the respondents and then we get some issues from the DPP says there's nothing to
I will start from that statement. Clarify that I have something of importance for us. Let not counsel speak for me. Your Honor, an allegation was made here by Counsel Zebra, but I did admit that the person speaking should be allowed bail. That is not the position. Let me put it, and I repeat myself by the career so that counsel can have it properly. I said in the unlikely event that this court will not grant us the fair sort of application. That's stringent measure taken. And in plain English, by bad luck, this court finds an issue.
In the post, Your Honor, could you imply that the Honorable Court in the reasons of discretion is a bad luck?
No, I was just translating in plain English. Further to that, there was another issue that probably could address, the issue regards to mobile phones. Your Honor, the procedure for extraction and application must be brought to court. The same has been made known to this court that there is a need for the same information to be extracted, and that is the direction of this court. We have not yet extracted because even the timelines do not allow us to suggest the same referencing. Your Honor, the main issue in regards to why the officer is seeking custodial orders for the same suspect is that the notice investigation completed due to the short nature and the provisions of our Constitution that the arrested persons must be released for 24 hours. Some aspects of the investigations can proceed while the persons in court are out on bond, but some cannot take place when they are outside. Your Honor, we request this court to grant us the order as we, from the application, it's clear.
Your Honor, counsel is supposed to respond on pure points of law, not facts. So you need to limit yourself to the law.
I'm just referring.
But you cannot
I'm
limit the facts.
responding to an issue that was brought up.
No, but you have to limit yourself to the issues of law. That's the response.
Yes, that's all. And let me proceed. Otherwise, we will taking up everywhere, actually consuming a lot of process. Your Honor, what is becoming an application is seeking precisely what is provided for under the law. Section 26 says, I can quote it, Your Honor, where there are compelling reasons for believing the suspects shall not appear for trial, or may appear with witnesses. Your Honor, the same is declarated in the application. We have shown that there is continuous excitement of the member of the public. Section, the same section also provides that unconditional release cannot be, suspect can also be detained longer to allow the IO or the officers to conduct investigation. Your Honor, finally,
we just find that the approach taken is a bit malicious because he's not citing the law in totality. He's reading a part. Anyway,
okay, section 36A, for subsection
I am at that particular section.
Subsection.
Perhaps more importantly, Your Honor, with your permission, if I can raise my name, the issue I have with the response is that the counsel is misleading the court. When he says that there are issues of interference in the affidavit, that has not been declared in that affidavit. That is not in the affidavit. There is no possibility of interference when that has not been deponed by the officer doing the investigation. So on that point alone, then it cannot be said, it cannot be misleading the court.
And that is the risk of when counsel goes on a fishing expedition and fails to confine himself to a response on points of law. Can't address points of law.
So, Your Honor, what I was indicating to the court, probably my language is not palatable. Maybe let me take out the
But that's a point of fact. How shall we respond? Can't you? We are not on our feet.
Yes.
But you cannot raise new issues.
So, as I was informing this court, where there is a likelihood to commit an offense or continuance of the offense, and the same is indicated in the application by the officer, And if I would be precise, I think Council that is in paragraph Ronald of the affidavit. Paragraph 7. That is, the respondents may continue to disrupt peace and tranquility. Your Honor, let me take this. You've told me to read it, and I've read it.
You know, the risk that the council is inviting us to is when you allow him to regurgitate the facts. If he does not have anything to say, you see, we just take this.
So, Your Honor, I'm just saying. That's one thing that it's the detention of the same person before court. There is a likelihood of continuous committing of the offense, and the same we urge the court to allow this application in its totality, seeking for the 14 days. I think I've responded to all those issues that have been there. The final issue that has been brought on issues of the breach of certain violations of the Prosecution. There's a proper forum for the same Prosecution report where they say the applicants, whether they were denied counsel, presentation, and all, can be dealt with and canvassed properly. That will be
Your Honor, there is an issue he has brought up, just one issue, saying that this court can grant the order for the phones, for information to be extracted by the phones. This court cannot. And I urge you to look at the notice of motion. It has only one prayer: to detain them. They have assumed they have the right to rummage through the property of the gentleman on the dock. So that is not a prayer you can grant. It's not asked for.
One word, Your Honor. Set the senator free, and you can give them information. Thank you very much. Set them free. Yeah, we are dealing with a country that has no respect at all. No respect for the Constitution. And the prosecutor does not approve the votes you have taken.
I need to happy new year. I just noted that the gentleman in the torn shirt was actually abducted this year. I don't know whether anyone can remember. He was abducted for about 5 days. I got very conscious, mindful. This may be just another way to abduct him.
In fact, the senator was abducted, but now it has been turned into a legal thing. But at the beginning, he was actually abducted. They were all abducted.
moving on to further. The application will be sending was filed on the 21st of June 2024 and have been filed by the DPP seeking for orders that the 23 respondents for the court report be retained for 14 days to enable their applicant that is the DCI sent to Nairobi to complete investigation. They have relied on the grounds on the face of the application, together with the supporting affidavit, sworn by Corporal Anthony Kerini. In brief, they state that the 23 respondents were arrested in Nairobi CBD and that they were booked by Central Police Station, that an OB was provided for receipt, that the mobile phones of the state suspects were taken, and that are to be subjected to Communications Authority of Kenya, that they are to extract messages, WhatsApp messages, Facebook, X messages, photos taken, that are inciting to members of the public against the state. that they are yet to obtain CCTV footage, record witness statements, and that in the end, should they be released and continue to disrupt peace and tranquility within the country, and that they are a threat of peace and stability. We had many counsel appearing for the respondents. They have given their response. Among them, they have quoted sections of the Constitution on the rights of the accused person. They have also raised the issue on conditions of the accused persons who have been arraigned before this court. They have also stated the law on what is to be considered for the grant of bonds, which is compelling reasons for the court to consider. They have raised the rights of an accused person to picket and to hold peaceful demonstration. They have also raised an issue that the affidavit that is before court does not disclose any offense, but they are mere speculations. That the investigations to be carried out will not require the presence of the accused person, and that the court has the discretion to grant both bail and bond to the accused person, and that the same has not been objected to. That the prosecution have not demonstrated the disharmony or the breach of peace that is being alleged. That the affidavit seeks an omnibus incarceration of all the 23 respondents who are to be held in custody for 14 days pending investigation. That the same is arbitrary and an abuse of the court process. That the investigations are already prejudiced, that court orders were not obtained to extract information from the said phones belonging to the respondents, and that the court has to balance the rights of the accused person while looking at the said application. In my analysis and having heard all the submissions that have been made by the prosecution and the defense, I have considered the law, the issues that have been raised. I have also considered the nature of the offenses that have been stated in the said affidavits. I will agree with the defense that the same are misdemeanors. I have also looked at the said application and the number of days that is being asked for, which is 14 days. The prosecution, in stating, making a request for the said date, has also stated that there are some aspects of the investigations that will not require the presence of the respondents before this court. This has been raised by the respondents' counsel. The issue of the CCTV cameras, recording of witness statements, will not require the presence of the accused persons in custody. More particularly, what has been stated was that the accused person are a threat to breach of peace. Therefore, from the evidence, from the material that has been placed before me and the law, looking at the compelling reasons, the court has looked at what has been submitted and agree with the defense that the court has to balance the rights of the accused person while granting the orders that has been sought. In considering the nature of the cases that the IO wishes to investigate, the court also considered Article 29 of the Constitution, which provides for the rights and freedom of the accused person. It states that every person has a right to freedom and security of person, which includes the right not to be deprived of freedom arbitrarily or without just cause. The same should be done without, if the same is done without trial, the same should not be done without trial except during a state of emergency, in which case detention will be subject to Article 58. Article 24 of the state constitution also on the rights and fundamental freedom on the Bill of Rights shall not be limited except by law. Therefore, in my analysis, so far as the bond and bail is concerned, there must be compelling reasons not to grant the same. The court bond promotes values that underlie the open and democratic society based on human dignity and equality, equity and freedom. It therefore follows that the function of bail is to ensure presence of accused person to attend the trial. Be as it may, the nature of the offences as stated does not disclose or warrant detention of the respondents. The state have failed to prove that the investigation will call for limitation of respondents' liberty and require them to facilitate or conduct investigations. However, I would wish to point out that justice demands thorough investigation, and at the end of the day, if investigations reveal that the respondents are not culpable, justice will have been served, and the course of justice therefore will not be a smooth ride. And based on that, I will allow that I'll make the following orders: that the 23 respondents herein will be released on bond. I hereby grant them a bond of Kenya shillings 50,000 with a surety of similar amount, each one of them. 5,000. I will also direct that they report to the investigation board pending investigations. We'll mention the case after 14 days.
So they've been released on a bail of and a surety for the same amount. They've been released on a bond. Quite unfair. You will reappear in court in the next 14 days.
Your Honor, tremendous respect. We appreciate the ruling of the court. And before Senior Counsel will say anything, I just want to point out one thing. Your Honor, it is the 31st of December 2024, meaning that tomorrow will be a new year. Just on that basis and on the basis of humanity, and I have spoken to my colleague from the DPP, as we welcome the ruling, I am making an application to review one term, just one, on the cash bail. I am proposing this. I am making a proposition that because it is a new year, Your Honor, you do review the cash bail term to a personal bond, or because we are all officers of the court, you review it to 1,000, which I shall pay personally as an officer of the court to secure their release today, so that on the day that the court will order they come back, we will come back on that day. 5,000 for most of them, if not all. I believe the good senator also has not seen his parliamentary service fund. He will not be able to get off. So even for the senator, I will pay the 1,000 for him. I am asking on humanitarian grounds that you do review the cash bill, and all of them may be sick. Just 1,000. My good colleague from the PPP, I have spoken to him, is also a man of God. He says that he does not see the challenge in the review. Just that. Just that. It is equally your voter.
May I take Your Honor? We can't do it. But as my other friend has said, we are all Even millionaires a long time ago are now pauper. I don't have 5,000 shekels. I have to tell you the truth as a Christian, I do not have 5,000 shekels. Donor, wave the cash there. Let these young people, they are poor people, let them go and join their families and celebrate the new year with their families. They will be here. No one wants to leave Kenya. Kenya is the most beautiful country in the world.
Please spoil the regime.
Yeah. Thank you. My friend has put a rider. It is appropriate. It's the most beautiful country, except we have for a long time lacked property.
As a man of God.
We hear that word very much in the
He means it.
Jonah, the court that so you run your court that is not the agreement. And also, whatever amount you put, that there will also be a right that there will be a contact person. For each and every 23 of them for the attendance.
There is a senior counsel.
I don't want senior counsel to be taken for
No, if we say contact person, it will complicate, and with the time remaining, there will not be case.
Yes.
I offer to be the contact person for the 20.
Thank you very much, Imran. Yeah, thank you very much.
You have seen the DPP has not proposed the limit to 1,000.
No, I did not say the amount.
I already have it on M-Pesa. Anytime the court directs you, just throw it to case. We walk out with our fellow brothers.
Freedom fighters.
Yeah, when this president is still receiving, it's not in perspective. The very fact that they have put some of us who are here in this courtroom means that they are all receiving. If they don't obey the court orders, I will definitely not come to the court. And I don't understand. The very fact that they have put me here, it's not the court matter, our former Minister of Justice. Means that they are people with comply the court. The young people, poverty stricken, hungry,
And broke.
And taxed.
and for holding the law of the government. And for holding the law of the government. We thank you very much.
Okay, then how about that?
Your Honor, one word. Permit me to my colleague at the back. Wish you a happy and prosperous new year.
Honor, before you get honor, we humbly tell to make an application because they have mobile phones and personal belongings. The rest.
I would allow our senior to close to us and wish the court happiness.
Dr. Kabelo has already wished the court happy new year, and all the court attendees and all those present. including
We no longer need a contact person.
you did not put that condition. Yes, we'll be present.
Happy New Year.
Happy New Year. Happy New Year. Happy serikali wa kule. Sisi wa jenzi wa KFC. Sasa Kimani Ichung'wa aseme. Kimani Ichung'wa tupatie 1000 ya KFC. Ujue tuko na pesa.
Make sure sound in a bit. Control sound vizuri. Mingi sana kuna mwingine atakusaidia mingi na nashika simu just shut us speak. Just shut us speak. I shall be very brief because I've got a new engagement. My here now, just now. He has a sense of fairness, he has a sense of justice, and that's what we need. Those of you who are young may not know that very much about this country. This country is where it is because of the judiciary. We have had judiciary on the whole. In recent times, which one can say has been strong, has been independent, and we should continue to support it. Without the judiciary, we without a strong rule of law in the country, we would probably not be where we are at the moment. We still feel that we should have hope, continue to have hope in the judiciary. And this magistrate has shown us what it is, that as we start the new year, we should proceed united and make sure that the rule of law in the country will be upheld. It is unfortunate that the conduct and behavior of what is going on, our young men or young women disappearing from the country, is disgraceful and despicable. No wonder that some individuals have decided to go to The Hague and file a suit there because of what happened. People just disappearing in the country is something that happens in our country that one can refer to as a banana republic. Kenya is going to a country, and we continue to feel that we are going to a country. Let those who are behind disappearances learn a lesson and stop abducting young people and giving also lessons in their lives. Thank you very much.
Well, my name is Patrick. A couple of big
kwa sababu ndio kuna history ya kila kitu.
Innocent, but what is right and what is easy, it should be encouraged, this should be the norm each and every day. Frustrated candidates are first to actually fight for their own rights. Equally, as part of the and the release of Ronnie and 4 Bernard as well, Peter, all those candidates who are abducted, to be released without they can't join the families, because it's quite disheartening that we are trying to roll back, from where we once tried to run away from. So abductions, arbitrary arrest, equally should not be encouraged. So we are happy that they have been released today, those who are arrested, and we thank the Law Society of Kenya for always standing firm, for always standing true to its call to protect, safeguard, and defend the rule of law. So with me, the Vice President of the Law Society of Kenya, Mr. Mora Kabata, I would just invite him to say a word or two. Thank you.
Tumefurahi kama jamii ya mawakili kupata mandugu zetu 23 wamepatiwa uhuru wao mahakamani kwa shutuma za polisi ambazo sio za halali kwetu sisi. Tumezidi kuendeleza ama kuhimiza mahakama kwamba mambo haya ya serikali ambayo sisi hatuambatani nayo ama hatuelewani nayo, ni kwamba wananchi wana haki za kuungana, kuandamana na kufanya maandamano ya amani, na kwamba njia yoyote ambayo sio ya kisheria ya kuuzilia mbali haki hizi, sisi kama jamii ya mawakili tutasimama kidete, tutahakikisha kwamba sheria ya kikatiba na wala sio sheria ya kiimla ndio itakuwa inafuatwa. Tumefurahi kwa sababu leo kipindi cha mwisho, siku ya mwisho ya mwaka huu wa 2024 tumepata maelekezo thabiti ya kisheria na ya kikatiba, na kwamba hawa mandugu zetu 23 leo watajumuika na familia zao, watafurahia mwaka mpya wakiwa huru. Alafu tutarudi tarehe 21 kuja kufanya ama kuchukua maelekezo mengine kotini, lakini tunahimiza